Question 1. A customer, Sarah, informs her registered representative that she is moving and provides a new mailing address. Which of the following is a required step for the firm to take regarding this change? A. Immediately implement the change without further verification if Sarah is a long-standing client. B. Send a confirmation of the address change to both the new and the old address. C. Only update the address after receiving a notarized letter from Sarah. D. Inform Sarah that address changes can only be made in person at a branch office. Answer: B. Send a confirmation of the address change to both the new and the old address. Sending a confirmation to both the new and old addresses is a key investor protection measure designed to prevent unauthorized changes and potential account takeover fraud. This procedure, often mandated by firm policy and regulatory expectations under rules like FINRA Rule 4512, Customer Account Information, ensures the legitimate account holder is aware of the change. For instance, if a fraudster attempted to divert mail, the real Sarah would receive a notice at her old, correct address, alerting her to the unauthorized activity. Always remember, firms must take reasonable steps to verify the authenticity of customer instructions, especially for critical information like an address. Question 2. When opening a new cash account for an individual, which piece of information is the firm not explicitly required by FINRA rules to obtain from the customer prior to the first transaction? A. Customer's name and residence. B. Whether the customer is of legal age. C. Customer's educational background and highest degree earned. D. Customer's tax identification number, e.g., Social Security number. Answer: C. Customer's educational background and highest degree earned. While a customer's educational background might be gathered as part of a broader suitability assessment or general know your customer efforts, it is not an explicitly required piece of information for account opening under FINRA rules like Rule 4512. Essential information includes the customer's name, address, date of birth, to verify legal age, and tax ID number for identification and regulatory compliance. For example, a firm needs the tax ID for reporting investment income to the IRS. So, while knowing more about a client is good, specific data points like their college degree aren't on the mandatory checklist for simply opening the account. Question 3. A customer opens a joint account with rights of survivorship, JTWROS. If one of the account holders dies, how are the assets in the account typically handled? A. The deceased's portion of the assets is distributed to their estate. B. The entire account is immediately frozen until a court order is received. C. The surviving account holders automatically inherit the deceased's share of the assets. D. The assets are liquidated, and the proceeds are split equally among the surviving owner and the deceased's beneficiaries. Answer: C. The surviving account holders automatically inherit the deceased's share of the assets. The core feature of a joint tenants with rights of survivorship, JTWROS, account is that it allows for the direct transfer of account assets to the surviving joint owners upon the death of one owner, bypassing probate. This right of survivorship means the deceased individual's share doesn't go to their estate or beneficiaries named in a will, it goes directly to the other account holders. For instance, if a husband and wife have a JTWROS account and one passes away, the surviving spouse becomes the sole owner of all assets in that account. Think of JTWROS as last one standing gets it all for the account assets. Question 4. Which of the following situations best describes a registered representative exercising discretion in a customer's account without proper authorization? A. Recommending a specific mutual fund based on the customer's stated investment objectives. B. Executing a trade for 100 shares of ABC stock after the customer specifically requested to buy 100 shares of ABC stock at the market price. C. Deciding to sell a customer's holding of XYZ mutual fund because of negative market news, without first consulting the customer. D. Providing a customer with research reports on several different investment products. Answer: C. Deciding to sell a customer's holding of XYZ mutual fund because of negative market news, without first consulting the customer. Discretion is defined as the authority for a representative to decide one or more of the 3 A's: asset, which security, amount, how much, or action, buy, sell, without the customer's specific instruction for that trade. If a representative makes a decision on any of these elements, such as deciding to sell a security, action, like XYZ mutual fund, without the client's prior consent for that specific trade, it's an exercise of discretion. To do this legitimately, the representative must have prior written discretionary authority from the client and principal approval for the account to be discretionary. Simply recommending a fund or executing a client-directed trade is not discretion. Question 5. A wealthy individual wishes to open an account identified only by a symbol and number, not by their name, to maintain privacy. Under FINRA rules, this is permissible provided: A. The customer pays an additional fee for the enhanced privacy. B. The customer is an institutional investor. C. The firm obtains a written statement from the customer attesting to ownership of the account. D. The account only holds U.S. Treasury securities. Answer: C. The firm obtains a written statement from the customer attesting to ownership of the account. FINRA rules permit numbered or coded accounts for customers seeking privacy, but this doesn't mean the firm can be ignorant of the true owner. The firm must still obtain and keep on file a written statement from the customer attesting to the ownership of the account, along with all other standard identifying information required under Customer Identification Program (CIP) rules. So, while the account statement might show account number 123, the firm internally knows who account number 123 belongs to. This ensures that while the client gets some privacy on account statements, the firm meets its regulatory obligations, including those related to anti-money laundering. Question 6. An elderly client with a very conservative risk profile and a primary investment objective of capital preservation mentions being interested in a new, highly volatile sector-specific mutual fund after seeing an advertisement. The registered representative should: A. Execute the trade immediately as requested by the client, as it is an unsolicited order. B. Refuse to discuss the fund as it is clearly unsuitable. C. Discuss the fund's risks and how it aligns, or misaligns, with the client's stated objectives and profile, and document the conversation. D. Recommend a larger investment in the fund to potentially offset its volatility with higher returns. Answer: C. Discuss the fund's risks and how it aligns, or misaligns, with the client's stated objectives and profile, and document the conversation. Even if an order might be unsolicited, a registered representative still has a responsibility to consider suitability and act in the customer's best interest under regulations like Regulation Best Interest, Reg BI, and FINRA's suitability rule. This involves discussing the investment's characteristics, including its risks, especially when it seems contradictory to the client's profile, like a volatile fund for a conservative, capital preservation-focused client. If the client still wishes to proceed after understanding the risks and misalignment, the representative might execute it as unsolicited but must document the discussion. Simply refusing or blindly executing isn't appropriate. Question 7. Under FINRA rules, which of the following constitutes a customer complaint that must be handled according to specific firm procedures, including forwarding to a principal? A. A verbal expression of dissatisfaction from a client about a recent market downturn. B. An email from a client stating, "I am very unhappy with the service I received regarding the delay in my withdrawal request." C. A marginal note written by the representative on an internal form indicating the client was a bit annoyed by a fee. D. A client's spouse calling to say the client found the latest research report confusing. Answer: B. An email from a client stating, "I am very unhappy with the service I received regarding the delay in my withdrawal request." A customer complaint, as defined by FINRA, is any written grievance by a customer or a person authorized to act on their behalf involving the activities of the member firm or its associated persons in connection with the solicitation or execution of any transaction or the disposition of securities or funds of that customer. An email clearly expressing dissatisfaction with service regarding funds, like a delayed withdrawal, fits this written grievance definition. General grumbling about the market or third-party comments usually don't meet the threshold, but a direct, written statement of unhappiness about the firm's actions does. Always treat written grievances seriously, as they trigger specific handling requirements. Question 8. According to Regulation SP, Privacy of Consumer Financial Information, when must a firm generally provide its initial privacy notice to a new customer? A. Within 30 days after the account is opened. B. Not later than when the customer relationship is established. C. Only if the customer opts out of information sharing. D. Annually, starting 1 year after the account opening. Answer: B. Not later than when the customer relationship is established. Regulation SP requires financial institutions to provide customers with a clear and conspicuous notice of their privacy policies and practices, both at the time the customer relationship is established and annually thereafter. This initial notice is crucial because it informs the customer how their non-public personal information will be handled, collected, and shared, and provides them an opportunity to opt out of certain sharing. For example, when someone opens a brokerage account, they should receive this privacy notice as part of the account opening package. Remember, the initial notice is upfront, not delayed. Question 9. A client has set up a transfer on death (TOD) registration for their brokerage account. What is a primary benefit of this type of registration? A. It eliminates all estate taxes due upon the owner's death. B. It allows the account assets to bypass probate. C. It provides a step-up in cost basis for the beneficiaries only if the assets are sold immediately. D. It allows the named beneficiary to make investment decisions for the account while the owner is alive. Answer: B. It allows the account assets to bypass probate. A transfer on death (TOD) registration allows the account owner to designate beneficiaries to receive the account assets directly upon the owner's death, without the need for those assets to go through the often lengthy and costly court process known as probate. While TOD registration facilitates a smooth transfer and avoids probate, it does not eliminate estate taxes if the estate is large enough to incur them, nor does it grant the beneficiary decision-making power while the owner is alive. Think of TOD as a direct route for assets to beneficiaries, sidestepping the probate detour. Question 10. A registered representative receives a call from an individual claiming to be the executor of an estate for a deceased client. Before providing any account information or executing transactions, the representative must first obtain A. A verbal confirmation from a known family member. B. A copy of the client's will. C. An official death certificate and appropriate legal documentation, e.g., letters testamentary, proving the executor's authority. D. A notarized statement from the executor. Answer: C. An official death certificate and appropriate legal documentation, example, letters testamentary, proving the executor's authority. When an account owner dies, the firm must take steps to ensure that only authorized individuals act on behalf of the estate. This involves obtaining official proof of death, typically a death certificate, and legal documents such as letters testamentary, or letters of administration if there's no will, that appoint and authorize the executor to manage the deceased's affairs. A will alone isn't sufficient, as it needs to be validated by a court, and verbal confirmations are not legally binding for this purpose. Always verify legal authority with official documents before acting on instructions for a deceased client's account. Question 11. A new client, age 30, wants to open an account and invest exclusively in aggressive growth mutual funds. The client has a high risk tolerance and a long-term investment horizon. When completing the new account form, which information is critical for the representative to document to support the suitability of these investments? A. The client's annual salary for the past 5 years. B. The client's specific college major and graduation year. C. The client's investment objectives, risk tolerance, and time horizon. D. The names of other brokerage firms the client has used. Answer: C. The client's investment objectives, risk tolerance, and time horizon. FINRA's suitability rule, and principles under Regulation Best Interest, requires firms and representatives to have a reasonable basis to believe that a recommended transaction or investment strategy is suitable for the customer. This is based on information obtained about the customer's investment profile, which critically includes their investment objectives, example, aggressive growth, risk tolerance, example, high, and time horizon, example, long-term. While salary is part of their financial situation, the objectives, tolerance, and horizon directly relate to the appropriateness of aggressive investments. Documenting these key factors is essential for justifying investment recommendations. Question 12. If a customer wishes to grant trading authority to a third party, example, an investment advisor or family member, over their account, what is generally required? A verbal agreement between the customer and the third party, noted by the representative. B. A completed power of attorney form specific to the account, signed by the customer. C. A letter from the third party stating their qualifications to manage the account. D. The third party must also open an account at the same firm. Answer: B. A completed power of attorney form specific to the account, signed by the customer. To grant trading authority to a third party, the customer must provide the brokerage firm with a written power of attorney, POA, specifically authorizing that individual to act on their behalf for the account. This legal document details the scope of the third party's authority, which could be limited, example, only to make trades, or full. Verbal agreements are insufficient, and while the third party's qualifications might be of interest, the POA from the customer is the key legal requirement. This ensures the firm is acting on the customer's explicit, documented instructions when accepting orders from someone else. Question 13. Which of the following account types inherently avoids probate upon the death of an owner? A. Individual account with a will naming a beneficiary. B. Tenants in common, TIC, account. C. Custodial account, UGMA/UTMA. D. Joint tenants with rights of survivorship, JTWROS, account. Answer: D. Joint tenants with rights of survivorship, JTWROS, account. A joint tenants with rights of survivorship, JTWROS, account is specifically designed so that when one owner dies, their share of the account assets automatically passes directly to the surviving joint owners, thereby avoiding the probate process for those assets. In contrast, assets in an individual account, even with a will, typically go through probate. Assets in a TIC account pass to the deceased owner's estate, and custodial account assets legally belong to the minor and will be managed by a guardian or successor custodian if the original custodian dies. The rights of survivorship feature is the key to bypassing probate in a JTWROS setup. Question 14. A customer opens a UGMA, Uniform Gifts to Minors Act, account for their nephew. Who is responsible for paying taxes on any income generated in this account? A. The custodian, using their own tax rate. B. The minor, at the minor's tax rate, though the custodian is responsible for filing. C. The donor who gifted the assets to the account. D. The account is tax-exempt until the minor reaches the age of majority. Answer: B. The minor, at the minor's tax rate, though the custodian is responsible for filing. In a UGMA, or UTMA, account, the assets legally belong to the minor, and therefore, any taxable income, like dividends or capital gains, generated by the account is taxed to the minor at the minor's tax rate. While the custodian manages the account and is responsible for ensuring taxes are paid, the tax liability falls on the minor. Special, kiddie tax rules may apply, potentially taxing some of the minor's income at the parent's rate if it exceeds certain thresholds, but the fundamental principle is that the income is the minor's. It's a common misconception that the custodian or donor pays. Question 15. When a registered representative receives a written customer complaint alleging unauthorized trading, what is the most appropriate initial action for the representative to take? A. Immediately contact the customer to try and resolve the issue directly. B. Disregard the complaint if the representative believes it is unfounded. C. Forward the written complaint to their supervising principal or compliance department. D. Offer the customer a refund for the disputed trades from their own funds. Answer: C. Forward the written complaint to their supervising principal or compliance department. FINRA rules require member firms to have procedures for handling written customer complaints, and these typically mandate that representatives immediately forward such complaints to a designated principal or the compliance department. Attempting to resolve it directly, especially allegations as serious as unauthorized trading, can interfere with the firm's required investigation and record-keeping processes. A principal must review the complaint and determine the appropriate course of action. Think of it as escalating any written grievance promptly to the correct internal channels. Question 16. A husband and wife maintain a joint account as tenants in common, TIC. If the husband dies, what happens to his portion of the account assets? A. His share automatically passes to his wife. B. His share is distributed according to his will or, if no will, state intestacy laws. C. The entire account is frozen until the wife provides a new account application. D. His share is forfeited to the brokerage firm. Answer: B. His share is distributed according to his will or, if no will, state intestacy laws. In a tenants in common, TIC, joint account, each owner has a distinct, undivided interest in the account, and there is no right of survivorship. This means if one owner dies, their share of the account assets passes to their estate, to be distributed according to the terms of their will or by state intestacy laws if they die without a will. It does not automatically go to the surviving joint owners as it would in a JTWROS account. So, for TIC, remember each owner's share is treated separately upon death. Question 17. Under the Customer Identification Program, CIP, rules, which of the following is not a required piece of identifying information a firm must obtain from a customer opening an account? A. Name. B. Date of birth. C. Residential or business street address. D. Occupation and employer's name. Answer: D. Occupation and employer's name. The Customer Identification Program, CIP, part of the USA Patriot Act, requires firms to obtain specific identifying information, name, date of birth, residential or business street address, and an identification number, like a social security number for U.S. persons. While information about a customer's occupation and employer is often collected for suitability purposes, FINRA Rule 2111, or general KYC, it is not one of the core 4 pieces of identifying information mandated by the CIP for identity verification. CIP is focused on verifying who the customer is, not necessarily what they do for a living, for anti-money laundering purposes. Question 18. A client calls their registered representative and states, "I'm very upset about the performance of my aggressive growth fund, I've lost money, and I think you gave me bad advice." This statement should be treated by the firm as A. A casual remark not requiring formal action. B. A potential customer complaint if subsequently put in writing by the client. C. An immediate customer complaint requiring documentation and principal review, even if only verbal. D. Grounds for automatically liquidating the fund to appease the client. Answer: B. A potential customer complaint if subsequently put in writing by the client. FINRA defines a customer complaint as a written grievance. While a verbal expression of dissatisfaction like this is serious and should be addressed by the representative, perhaps by discussing the fund's objectives, risks, and market conditions, it doesn't meet the formal definition of a customer complaint requiring specific FINRA reporting and handling unless it is submitted in writing. Firms may have internal policies to document significant verbal dissatisfactions, but for FINRA purposes, the trigger is typically a written statement. The rep should listen empathetically and address the client's concerns, and if the client later writes down their grievance, it then becomes a formal complaint. Question 19. Mrs. Smith, an elderly client, contacts her representative to make a significant and uncharacteristic withdrawal from her variable annuity, stating she needs the money for a fantastic, can't-miss investment opportunity a new acquaintance told her about. The representative has concerns this might be financial exploitation. According to FINRA rules regarding temporary holds on disbursements, the firm may a. Place a temporary hold on the disbursement for up to 15 business days if financial exploitation is reasonably suspected. B. Refuse the withdrawal permanently as it seems suspicious. C. Only process the withdrawal if Mrs. Smith's adult children approve it. D. Advise Mrs. Smith that such withdrawals are not permitted from variable annuities. Answer: A. Place a temporary hold on the disbursement for up to 15 business days if financial exploitation is reasonably suspected. FINRA Rule 2165, Financial Exploitation of Specified Adults, allows firms to place temporary holds on disbursements of funds or securities from the accounts of specified adult customers, those age 65 and older or age 18 and older with a mental or physical impairment, when the firm reasonably believes financial exploitation has occurred, is occurring, has been attempted, or will be attempted. The initial hold can be for up to 15 business days, with a possible extension. This rule provides a safe harbor for firms to investigate suspicious situations and protect vulnerable clients, like Mrs. Smith in this scenario. Question 20. Which of the following is a key difference between a cash account and a margin account? A. Cash accounts can only hold cash, while margin accounts can hold securities. B. In a cash account, all transactions must be paid for in full by the settlement date. In a margin account, the firm can lend the customer part of the purchase price. C. Margin accounts are only available to institutional investors. D. Dividends received in a cash account are tax-free, while dividends in a margin account are taxable. Answer: B. In a cash account, all transactions must be paid for in full by the settlement date. In a margin account, the firm can lend the customer part of the purchase price. The fundamental distinction between a cash account and a margin account lies in how transactions are financed. In a cash account, the customer must pay for securities purchases in full by the settlement date. In a margin account, the brokerage firm can lend the customer a portion of the purchase price of eligible securities, with the securities serving as collateral for the loan. Both account types can hold securities, and dividends are generally taxable in both. Margin is not exclusive to institutions. The ability to borrow from the firm is the defining feature of a margin account. Question 21. A customer provides a P.O. box as their mailing address when opening an account. For Customer Identification Program, CIP, purposes, the firm must also obtain A. A utility bill showing the P.O. box address. B. A residential or business street address. C. The name of the post office branch where the P.O. box is located. D. A letter of attestation from the customer's employer. Answer: B. A residential or business street address. While a customer can use a P.O. box for mailing purposes, the Customer Identification Program, CIP, rules require firms to obtain a residential or business street address for an individual customer. If the customer provides an Army Post Office, APO, or Fleet Post Office, FPO, box number, or the residential or business street address of a next of kin or another contact individual for an individual who does not have a residential or business street address, that is acceptable. The core idea is that the firm needs a physical address for identity verification, as a P.O. box alone does not suffice for this specific CIP requirement. Question 22. A corporate resolution is a document generally required to open which type of account? A. Custodial, UGMA/UTMA, account. B. Joint tenants with rights of survivorship, JTWROS, account. C. Corporate investment account. D. Individual retirement account, IRA. Answer: C. Corporate investment account. When a corporation wishes to open an investment account, the brokerage firm will require a corporate resolution. This is an official document from the corporation's board of directors that authorizes the opening of the account and specifies which individuals, corporate officers, are empowered to trade on behalf of the corporation and enter into agreements. This ensures the representative is dealing with duly authorized persons acting within their corporate authority. Other account types like custodial, JTWROS, or IRAs have different documentation requirements specific to their nature. Question 23. If a registered representative suspects that a transaction in a customer's account may be related to money laundering, the representative should A. Immediately inform the customer of their suspicion. B. Refuse to execute the transaction and close the account. C. Report their suspicions promptly to their supervisor or the firm's designated AML compliance officer. D. Wait for at least 2 more suspicious transactions before taking any action. Answer: C. Report their suspicions promptly to their supervisor or the firm's designated AML compliance officer. Anti-money laundering, AML, regulations require registered representatives to report any suspicious activity that might indicate money laundering to their supervisor or the firm's AML compliance officer. Representatives should not inform the customer, which could be tipping off, or unilaterally decide to close accounts without following firm procedures. The firm's AML compliance officer is responsible for investigating further and determining whether a suspicious activity report, SAR, needs to be filed with FINCN. Prompt internal reporting is key. Question 24. A customer's account statement should generally be sent at least A. Daily, if there is any activity in the account. B. Weekly. C. Quarterly. D. Annually. Answer: C. Quarterly. FINRA Rule 2231 requires firms to send account statements to customers at least quarterly. However, if there is any activity in the account during a month, such as purchases, sales, or receipt of dividends or interest, a statement must be sent for that month. So, while active accounts get monthly statements, the baseline minimum frequency for all accounts, even inactive ones, is quarterly. This ensures customers are regularly informed about their holdings and any transactions. Question 25. An existing client informs their registered representative that they have recently been diagnosed with a mild cognitive impairment. This information is most relevant to the representative's ongoing obligations regarding A. The firm's Customer Identification Program, CIP. B. The calculation of margin requirements for the client's account. C. The suitability of investment recommendations and potential concerns about financial exploitation. D. The frequency of sending account statements. Answer: C. The suitability of investment recommendations and potential concerns about financial exploitation. A client's disclosure of a cognitive impairment is a significant factor in assessing suitability and being alert to potential financial exploitation or diminished capacity, as highlighted under FINRA rules regarding senior and vulnerable investors, like Rule 2165. This new information may impact the client's ability to understand complex investments or make sound financial decisions, requiring the representative to exercise heightened diligence. While CIP is for account opening, margin calculations are mechanical, and statement frequency is rule-based, the client's cognitive status directly impacts the ongoing assessment of what's in their best interest.